The honourable member for Beaches, East York.
Thank you very much, Mr. Speaker, and I'm pleased to be on my feet today to talk about Bill C-15 at report stage and deal with colleagues' proposed amendment to the bill, Bill C-15, an act to amend the National Defence Act and make consequential amendments to other acts. And I think the title, Mr. Speaker, is interesting. One wishes there was a kind of shorter handle on the title here, but it's also known and more commonly known as Strengthening the Military Justice in the Defence of Canada Act. And we've had lots of discussion this morning, Mr. Speaker, about the issue of relevance of the debate and what we're talking about. And I think what's important to understand and appreciate here is that this amendment that's before us for discussion and debate is a piece of a system, and it sits in a broader context of the military justice system, and it is important to understand the relationship of that amendment and the issues that are implicated by that amendment in the context of that broader justice system. And so you may recall, Mr. Speaker, that we had opposed this bill at second reading on this side of the House, but there's been an important amendment that's come out of committee that allows us to reluctantly support the bill when we move on to third stage. And I say reluctantly because the bill is still far from what it ought to be. It makes a number of changes to the military justice system in Canada that are positive, but not all of them are positive, Mr. Speaker, and that is why our colleagues' amendment to the bill is welcome today. It's an important issue to contemplate and debate. Now, let me say this about the bill. It's had a long history. It's 10 years in the making, Mr. Speaker, to get to this point, and it's important that it get a thorough vetting. The parliamentary secretary talks like his party wasn't in government for 7 of those years, but in fact they were, and he should be asking questions probably back in the lobby about why 7 years we waited around for this important bill to arrive. But nevertheless, there's a long history to this bill, and it emerges out of a couple of very comprehensive reports. The Right Honourable Antonio Lemaire had a crack at it back in 2003 and made 88 recommendations, which speaks, I think, is suggestive to some of the very significant deficiencies in the military justice system, Mr. Speaker. And there was a Senate committee report dealing on the same matters, and then again another report by former Chief Justice of the Supreme Court, Patrick Lesage, which I think the parliamentary secretary should contemplate why they sat on that report, in fact, for a year before bringing that forward if he's in such a hurry to see this bill and these changes implemented. And so in the interim, of course, Mr. Speaker, we've had elections. The Liberal Party had 2 years with it as well, and they didn't do anything. We've had Conservative prorogation, and it seems a general resistance. And in fact, we've even walked backwards from where we've been in earlier parliaments, where we had Bill C-41 that died on the order paper. And the significance of Bill C-41, Mr. Speaker, is that it dealt with a very important issue to our party, and that is the issue of summary trials and the number of offenses, service-related offenses that can proceed through summary trial and actually result in a criminal record. And former Colonel Michel Drapeau has spoken at length about the unique nature of military justice systems and the need to balance issues of an expeditious justice system, providing for deterrence and ensuring discipline and the importance of that to an efficient armed forces, but also ensuring that the rule of law predominates. And so you get in the military justice system this summary trial process, Mr. Speaker, which which in the normal course out in civilian life we wouldn't recognize as really a form of fair justice. Frankly, it's your own commander could sit in judgment. There's no transcripts, no right to counsel, et cetera, et cetera. And the importance of that, Mr. Speaker, is that about 95% of cases that go to trial go through this system. And so now I will say that and why we're supporting this bill is that at the end of the day, we've managed over the years to persuade the Conservative Party that fewer of the offences that can go through the summary trial procedure can actually attract a criminal record that a member of our armed forces might take into their civilian life, and so that the Bill C-15 will lessen the number of those offenses, and that is a very positive thing, and that's why the bill is, with or without this amendment, worthy, I think, of our support. But nevertheless, we are left with an approximate form of justice here with this summary trial process, and this is where the importance, Mr. Speaker, of the amendment comes in, because it's the investigation that precedes that approximate form of justice that becomes extremely important, and that investigation process must be done properly. Now, what the Conservatives have done here is they've taken the accountability framework that was put together post Somalia inquiry that set out the relationship between the Vice Chief of Defense Staff and the Provost Marshal, and they're turning that administrative document into statute. A worthy thing to do, but in the course, Mr. Speaker, they've done something quite unfortunate, and that brings rise to the amendment today, and this amendment is worthy because what we do, what this bill does, Mr. Speaker, is it provides new powers to the Vice Chief of Defense Staff with respect to military police investigations, those very investigations that will end up in summary trials. And Clause 4 of the bill amends Section 15.5 Sub 3 of the National Defense Act to say that the Vice Chief of Defense Staff may issue instructions or guidelines in writing with respect to particular investigations. Now, what we have currently in the accountability framework, Mr. Speaker, is language that says that the Vice Chief of Defense Staff shall not direct the Provost Marshal with respect to specific military police operational decisions of an investigative nature. And further, Mr. Speaker, it says that under Section 7A, Vice Chief of Defense Staff will have no direct involvement in individual ongoing investigations, but will receive information from the Provost Marshal to allow necessary management decision-making. Now, those provisions are there, Mr. Speaker, and they flow from the principles and purpose of the accountability framework. And, of course, this accountability framework flows from the extremely unfortunate incidents in Somalia, which may have been last century, thank you, Mr. Speaker, but are critically relevant to this discussion today. And the purpose of that accountability framework that came out of the Somalia inquiry is to ensure the provision of a professional and effective military police service for independent investigations, to balance competing interests and priorities, and critically to ensure that the Provost Marshal is accountable to the Vice Chief of Defense Staff for developing and maintaining police standards which are consistent with those of other police agencies. Who in Canada would want to deny, Mr. Speaker, the men and women of our Canadian Armed Forces an investigation into alleged misconduct that is consistent with those of other police agencies? That's what the accountability framework allowed. History proves that it is a workable document and provided for reasonable, fair investigations leading into these summary trials, Mr. Speaker. And it is most unfortunate and very much a backward step to now have the government propose in Bill C-15 an investigation process that is inconsistent with those of other police agencies in this country, Mr. Speaker. Thank you.